welcome to the first of 3 Wills and Estate special Greens List breakfast briefings that Michael Green and the staff on our list have arranged for the Victorian Wills and Estate and Trust solicitors. I hope you enjoy this morning's 2 presentations and come along to the remaining 2 sessions that have been particularly planned by Michael Green and the staff at Green's office in consultation with various wills and estate barristers on our list. And hopefully we are providing a sufficiently broad topic base, recent development issues to assist you in conducting your practices. So welcome everyone. Very briefly, Teri Konstantinou, also known as Eleftheria Konstantinou in the Greek manner, will speak first. And before I just want to spend a few moments telling you about Teri Konstantinou, and she then will give her outline. Teri's only been on our list at Greens for a few years, and she was admitted as a barrister and solicitor in 2002, so she's been a barrister for a number of years. She is one of the new breed of blood that is on Green's list at the moment. She's young, she's vibrant, and I have watched her very closely over the years, and I'm going to tell you a story about her in a moment. And she works hard, she takes instructions very carefully from her clients, she has a real attention to detail, and I'm really delighted that she came to the bar and that she's on our list. I met Teri in 1990. She was a high school student in a pretty rough northern suburbs high school in Melbourne. She had a dream to be a lawyer, and I was then only at the bar for a few years. She rang the offices here at the Victorian Bar Council. She did that off her bat by herself because she wanted to do some work experience to learn the ropes of being a barrister or a solicitor. And the Victorian Bar Office, then Ed Fieldhouse, who ran the show many years ago, put her in touch with me because I had a policy at the time, before I had children, to assist young solicitors and barristers and students, basically high school students. I used to give them quite a bit of work experience, and it was something that I enjoyed doing when I was much, much younger. So Teri came along and I met her on the 9th floor of Owen Dixon Chambers West, where I then had my chambers, and she followed me around for a month. And I saw there a young lady who was very keen and had a real passion to be a lawyer. And gently, gently I kept saying to her, work hard, get into law, and then come to the bar. And she did that. She got into La Trobe University. The law school was only a few years old when Teri attended the law school there, and I had the great pleasure a number of years later to move her admission. So, ladies and gentlemen, Teri's profile is pretty clear. It's on Green's website. She is establishing a very solid practice, not just in wills and estates, but other areas. I look forward to hearing her speak. She is one to watch, as I said, on the list, and she will talk about various pitfalls in your wills and estate practices and how you are to avoid them. So, thank you, Teri.
Well, good morning and welcome everyone, and thank you, Georgina, for that quite slightly embarrassing introduction. I don't know what quite to say about that, but anyway, thank you very much for that. It's all true, unfortunately. I'm going to be talking about pitfalls in your wills and estates practice. Perhaps the biggest pitfall that, in my experience, most solicitors come across is time limits and complying with them. It's a jurisdiction that is quite severe in that regard, and I was recently involved in a case where my instructor inherited a file from a previous solicitor. The deceased was domiciled in Tasmania, and the client beneficiary was in Victoria and wished to make a testator's family maintenance claim. And the previous solicitor unfortunately assumed that the time within which to make that application in Tasmania was 6 months. In fact, under the Testator's Family Maintenance Act of that state, it's 3 months. So the client was in a position where they were already on the back foot and behind the 8 ball, having to make an application to now extend the time within which they were to make their application for a further provision from the will. And it puts you on the back foot in the sense that the substantive application takes a back seat to some degree. You've got to explain your delay. You've got to explain the unfortunate administrative oversight of the solicitor not appreciating the time limits in the other jurisdiction. So bear that in mind, because it really can, your client can be quite angry, understandably so, in having to now concentrate on justifying their position. So bear in mind interstate legislation, interstate rules of court and probate practice, and keep those time limits in mind. Applying for grant of probate, you need to first determine whether a grant is necessary. Excuse me. In small estates or estates where there is no real property, a grant is possibly not required. And in fact, it's the duty of the executor to not incur additional costs on an estate, of a small estate. And thank you, Georgie. So first determine whether a grant is in fact necessary. 14 clear days before you apply for a grant, you need to advertise your intention to apply. Now, that's no longer an advertisement in the newspapers. You now advertise on the Supreme Court website. You have regard to the administration probate rules of the Supreme Court. They will set out the procedure for you there. And Section 15 of the Administration and Probate Act, where the executor hasn't applied for a probate or hasn't renounced their right to apply for probate within 6 weeks of the death of the testator, then the court has the power to appoint an alternative substitute executor. So that's something to keep in mind. Where your client executor is seeking to apply for probate more than 3 years after the death of the testator, then you need to explain that delay, and that's done by way of affidavit as well, so keep those things in mind. I want to turn to caveats, because caveats is quite a complicated area. The first point I want to make about will caveats is that they are not a substitute for a testator's family maintenance claim. In most cases, clients want to in some way, I guess, punish the executor. The executor being, in most cases, will normally be a sibling, that is the sole executor and sole beneficiary of the estate, and there will be other siblings that have been left out of the will. And you may have a client that comes to you and says that they want to lodge a will caveat to prevent the executor from obtaining probate because they're angry that they have not been included in the will. I think it's important in that regard to, before you take instructions to lodge the caveat, probe a little deeper, because I think that you'll find that really the main motivation and agenda is the need for the client, or the want of the client, to make a TFM claim. And I think it's important to explain to clients in that situation that it's not bad to allow probate to take place. In fact, without probate, they can't make their TFM claim. And the will procedure is not the process by which they can assert their rights in that regard. So take the time to test your client's instructions. You may find that in fact, what they're wanting to do is something very different. Common challenges to wills, most notably lack of testamentary capacity, fraud and undue influence. Andrew will talk very in detail about the practical and legal difficulties about proving fraud and undue influence, so I won't go into that. But lodge your caveat as soon as you receive instructions to do so, because it may be the case that at that time the executor may have already applied for probate, and caveats may be lodged as 6 months within the date of grant of probate, so they expire within 6 months of the date. So be careful to ensure that time hasn't already started to run. Now, how do you know if probate has been granted so you can start the time, the clock ticking? You can do a number of things. You can, if you know the identity of the executor or the executor's solicitor, then it's worth writing to them and stating your client beneficiary's intention to make a claim and asking them to notify you when a grant of probate has been made. There is a notice that you can file in accordance with the probate rules with the Registrar of Probates, and the Registrar of Probates will notify you when a grant has been made, and you can begin the clock ticking from that point as well. Now, one other thing to note about caveats, if your client fails at the hearing of the caveat dispute to challenge the will, they will not be indemnified from the assets of the estate for the costs of doing so, unlike TFM claims where applicants' costs come out of their deceased estate. It's not the case with caveat disputes, and indeed where the executor can prove that they acted reasonably, it's possible that they may be entitled to costs on an indemnity basis for taking steps to oppose the caveat. So bear in mind those cost consequences and explain those to your client. Now, the real, most of you will be involved a lot with making a testator's family maintenance claim. Testator's family maintenance claims pursuant to Section 99 of the Admin Probate Act must be made within 6 months after the grant of probate. So now leave may be granted to extend that time as so long as the estate hasn't been finally distributed. Again, you can find out, you can lodge your notice with the registrar to ensure that time hasn't started to run already. And if you're acting for an executor and your client and you receive a notice from a potential claimant, Section 30 of the Admin and Probate Act is important to note. Where you receive a potential notification from a beneficiary that they intend to make a claim, you can serve on that beneficiary a notice compelling them to prosecute their claim within 3 months. Failing which the executor may then make an application to bar any further claims being made by that beneficiary after that 3-month period. So just note that section too for your own information. I want to move to rectification. A few points to note about that. You can apply to rectify a will within 6 months of the grant of probate. Again, you can extend that time as long as there's no final distribution of the estate. And the basis upon which you may seek rectification of a will is to convince the court there's a clerical error, such as the misspelling of a beneficiary's name or perhaps the misrecording of title particulars in respect of real property. But the more difficult ground seeking rectification of a will is that proving that the will does not carry out the testator's intentions. And whether you succeed or fail in that regard will depend very much on how well you keep your will file and how well you have managed your will file. And no better illustration there's no better illustration of that than in the recent case of Justice Pagoni and ANZ trustees and Hamlet, I understand there's a representative in the audience from the plaintiff in that case, so I apologise in advance for dredging up this case for you so early in the morning. Perhaps you want to just picture yourself at a tropical island somewhere for the next 5 minutes. Andrew was representing the third and fourth defendants, and his clients were supporting the plaintiff in their application for rectification in that case. Now, the plaintiff in that case did not succeed in rectifying the will. The dispute concerned the construction of a clause in the will dealing with the distribution of the residuary estate. What the plaintiff sought to argue was that various documents of the will on the will file, contemporaneous file notes of the solicitor, and the will planner document, which is an instruction precedent sheet that most of you use to obtain and record your instructions. They sought to argue that the intention of the testator, was that the residuary estate ought to be divided into 5 ways amongst the 5 classes of beneficiaries. And what the other defendants sought to argue was that, in fact, no, it should be distributed in 12 ways. So I'll just quickly continue discussing Hamlets Case, because there's quite a few important points to come out of that. So briefly, again, the facts were that the plaintiff sought rectification on the grounds that the will did not specifically evidence the testator's intentions, and they sought to rely on a number of documents. There were contemporaneous file notes of the solicitor and a will planner document, which is a precedent instruction sheet in which the recording of instructions take place. And Justice Pagoni found that there was nothing in the contemporaneous file notes or the will planner which specifically recorded the testator's intentions, which, as the plaintiff sought to propound, was that she wanted the distribution to be split 5 ways amongst the 5 classes of beneficiaries. He wasn't convinced that those extraneous documents in the will file propounded the construction of the clause in that way. And he had grave concerns about the instructions recorded by the solicitor in his file notes. And he also had grave concerns about the instructions recorded in the will planner document, because the final will that was sent to the testatrix for her execution was not clear that she wanted the residuary of the estate to be split 5 ways amongst the 5 classes of beneficiaries. And so His Honour was in a situation where he had 4 sets of documents, each intending to record the intentions of the testator, but in his opinion not clearly enough. And he could not make the orders sought by the plaintiff, because he was not satisfied that the extraneous documents supported the interpretation of the clause in the way that the plaintiff wanted to suggest that it should be interpreted. And the other point about that case was that the instructor who met with the client and took the instructions and recorded them in the file notes and the will planner was not actually the person that drafted the final will for her execution. And Justice Pagoni was quite critical of that. Obviously, the person who is responsible for obtaining instructions, meeting with the client, only they can have an intimate understanding of what their intentions are and what they seek to achieve in their will. To delegate that task to a third party where that intimate knowledge and relationship is not there is quite dangerous. So be careful to ensure that the person who is taking the instructions is the person that drafts the will. They are the ones that have the understanding of what is to be achieved. The final point about Hamlet's case is the cost consequences of making application to rectify a will. It shouldn't be assumed that if you succeed in your application that you will be awarded your costs. In fact, Justice Pagoni in Obiter held that, and in that case, ANZ trustees did not make an application for their costs. But His Honour indicated that had there been such an application, he would not have granted the costs of the plaintiff. And his reasons were that what you're doing is seeking to move the court to rectify a document which otherwise would not have been necessary had proper drafting taken place. And so that's quite important to note. And he also held that you're putting the defendant to the cost of having to propound an alternative argument to assist the court in determining how the will should be constructed. And that's not a cost that should be incurred by the defendant, because again, it would not have been necessary had the will been drafted in the way that the deceased had intended it to be drafted. So even if you do succeed on that ground, be prepared to not be granted your costs of the application. Some points to make finally about how your file management and your storage of wills in general, just very quick points. Most clients will tell you that they want to keep the will in their own custody. Discourage them from doing that if you can. And that is because if the will is destroyed or lost whilst in their possession, there is a presumption at law that the will has been destroyed by the testator with the intention of revoking it. So that's quite important. And where you're seeking to apply for grant of probate of a copy of a will, that presumption is quite difficult to displace. I've cited the case of Estate of Marcos, deceased re Machecha in my paper, and it's a good decision to read. In that case, the applicant successfully sought probate of a copy of a will, and Justice Beach did set out the principles upon which the presumption that I just mentioned may be displaced. So have a read of that. Essentially, where the copy will indicates a clear disposition of the assets of the deceased, and where there is no evidence of the disposition having been made in anger, or where there's no evidence of a falling out between the beneficiaries and the testator, the court will be more likely to displace the presumption and admit the copy will into probate. Record your deed numbers on your wills where they are stored in a vault or a deed safe, and where there are any codicils to the wills, ensure that your deed number corresponds with the codicil and the will to which it relates, so keep them together. Solicitors that instruct me also are very good at keeping their will file together with the will in the will safe. That way, where if you need to make an application for rectification, you have everything there all in one spot. And the person who puts the will in the safe or puts the will in the vault, their name should be recorded. In the event that they leave the practice, you need to know how to retrieve that will and where it can be found. So just be sure that that procedure is followed. I was going to mention Nicholson and Nags, but I won't, because that's for Andrew to do. So I'll leave that to him. But anyway, I hope that was useful, and apologies again for that break in the middle, and I'm happy to answer any questions at the end of Andrew's talk. So thank you again.
Thank you, Teri. The 3 points that I got out of Teri's very comprehensive paper, and it's a paper that needs to be read carefully and quietly in time. The 3 points that that helped me was to always keep an eye on probate time limits. I think that's an important task that both barristers and solicitors need to do. Secondly, how well you keep your will file is also very important at the various stages of the pre-estate administration period and the post-estate administration period. I think that's really, really important. And thirdly, never, ever, ever delegate the important task of taking instructions, particularly when you're in the course of making a new will for a client. I think non-delegation is the norm and should be the norm, as Justice Begoni and other judges have said in a number of cases. So thank you very, very much, Teri, for that comprehensive paper.